seated. Ladies and gentlemen, at this time I'll be instructing you. We provided you with the final instructions. So the preliminary ones that you had earlier on your seats have now been removed. Your notes have been kept intact. You can reorganize them accordingly. And at this time I'll be going over the final instructions with you. After the final instructions, closing statements shall begin. I'll now instruct you on the law that applies in this case. It is your duty to follow the law whether you agree with it or not. It is also your duty to determine the facts. You must determine the facts only from the evidence produced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion you may feel I have about the facts. You are the sole judges of the facts. You must take into account all of my instructions. In other words, you are not to pick out one instruction or part of one and disregard the others. However, after you've determined the facts, you may find that some instructions do not apply. You must then consider the instructions that do apply together with the facts as you have determined them. Decide the case by applying the law in these instructions to the facts. The state is charged the defendant with a crime or crimes. A charge is not evidence against the defendant. You must not think the defendant is guilty just because the defendant has been charged. The defendant has pled not guilty. The defendant's plea of not guilty means that the state must prove every part of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there is a real possibility the defendant is not guilty, you must give the defendant the benefit of the doubt and find the defendant not guilty. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proven beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. The crime of public sexual indecency requires proof of the following. 1. The defendant intentionally or knowingly engaged in an act of sexual contact. And 2. Another person was present. And 3. The defendant was reckless about whether such other person, as a reasonable person, would be offended or alarmed by the act. The crime of indecent exposure requires proof of the following. 1. The defendant exposed the areola or nipple of her breast or breasts. And 2. Another person was present. 3. The defendant was reckless about whether such other person or whether the other person, as a reasonable person, would be offended or alarmed by the exposure. Knowingly means that a defendant acted with awareness of the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known that conduct is forbidden by law. It is no defense that the defendant was not aware of the existence of conduct or circumstances solely because of voluntary intoxication. Intentionally, as used in these instructions, means that the defendant's objective is to cause that result or to engage in that conduct. Recklessly means, with respect to a result or to a circumstance described by a statute defining an offense, that a person is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard of such risk constitutes a gross deviation from the standard of conduct that a reasonable person would observe in this situation. A person who creates such a risk but who is unaware of such risk solely by reason of voluntary intoxication also acts recklessly with respect to such risk. If the state is required to prove that a defendant acted recklessly, that requirement is satisfied if the state proves that the defendant acted intentionally or knowingly. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. Intoxication means any mental or physical incapacity resulting from the use of drugs, toxic vapors, or intoxicating liquor. Voluntary intoxication means intoxication caused by the knowing use of drugs, toxic vapors, or intoxication liquors by a person, the tendency of which to cause intoxication the person knows or ought to know unless the person introduces them pursuant to medical advice or under such duress as would afford or defense to an offense. It is not a defense to any criminal act if the criminal act was committed due to temporary intoxication resulting from the voluntary ingestion/consumption of alcohol. Unlike voluntary intoxication, intoxication resulting from the involuntary use of alcohol or drugs may be considered in deciding whether the defendant had the mental state required to prove an offense. The state has the burden of proving beyond a reasonable doubt all the elements of the offense, including the required mental state. If you determine that the defendant became intoxicated solely as a result of drugs or alcohol administered to her against her will or without her knowledge, you should then consider whether the involuntary intoxication prevented the defendant from acting with a particular mental state or states required to establish the offense. If you have a reasonable doubt that the defendant had the required mental state for the offense, we must find the defendant not guilty. The state has presented evidence of alleged sexual contact between the defendant and underage boys. This evidence was not presented to show that this contact was unlawful and cannot be considered by you for such purpose. You may consider this evidence as it relates to other persons who were present and whether such persons, as reasonable persons, would be offended or alarmed. Something or someone that produces an effect, result, or condition. Something or someone that makes something happen or exist. Sexual contact means any direct or indirect touching, fondling, or manipulating of any part of the genitals, anus, or female breast by any part of the body, or by any object, or causing a person to engage in such contact. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. The defendant is accused of having committed the crime of indecent exposure in counts 1 and 2. The prosecution has introduced evidence for the purpose of showing that there may be more than one act upon which a conviction on counts 1 and 2 may be based. The defendant may be found guilty if the proof shows beyond a reasonable doubt that she committed any one or more of the acts. However, in order to return a verdict of guilty to counts 1 and or 2, all jurors must agree that she committed the same act or acts. It is not necessary that a particular act or acts agreed upon be stated in your verdict. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as with the testimony of any other witness. You must evaluate the defendant's testimony the same as any witness's testimony. Rules of evidence ordinarily do not permit the opinion of a witness to be received as evidence. However, a witness may testify to an opinion on a subject upon which the witness has become an expert because of education, study, or experience. You should consider the opinion of an expert and should weigh the reasons, if any, given for it. However, you are not bound by any expert opinion. Give the expert opinion the weight you believe it deserves. If you find that the state has lost, destroyed, or failed to preserve evidence whose contents or quality are important to the issues in this case, or in the case, then you should weigh the explanation, if any, given for the loss or unavailability of the evidence. If you find that any such explanation is inadequate, then you may draw an inference unfavorable to the state, which in itself may create a reasonable doubt as to the defendant's guilt. You are the exclusive judges of the evidence in this case. The word evidence, as used in these instructions, means testimony of witnesses, a writing, a material object, or other things presented to the senses that are offered to prove the existence or non-existence of a fact. A fact may be proved by either direct or circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances, indicating the guilt or innocence of the defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. From the evidence that has been presented to you in court and the reasonable inferences to be drawn therefrom, you must decide whether the state has proved the truth of the charge beyond a reasonable doubt. Your verdict must be based upon the evidence presented in court, not upon theories unsupported by proof in the case, nor speculation or guesswork. Your verdict should not be influenced by passion against the defendant, nor by sympathy for her, but should be fair, impartial, and based upon the facts in the case. You are the exclusive judges of the credibility of the witnesses who have testified in this case, which means that you must decide which witnesses are to be believed and how much weight, if any, is to be given to the testimony of each witness. In determining the credibility of a witness, you may consider anything which tends in reason to prove or disprove the testimony of the witness, such as the witness' conduct, attitude, and manner while testifying, whether the facts testified to are inherently believable or unbelievable, the capability of the witness to hear or see that about which is being testified to, and the ability to recollect or to relate such matters, whether or not there was any bias, interest, or other motive for the witness not to tell the truth. Any statement previously made that was consistent with the witness testimony, or conversely, any statement previously made that was inconsistent with the witness testimony. However, you should bear in mind that the discrepancies in witness testimony, or between that witness testimony and that of others, if there are any, do not necessarily mean that you should disbelieve the witness, as a failure of recollection is a common experience, and innocent misrecollection is not uncommon. We're all certainly aware of the fact that two persons witnessing the same incident will see or hear it differently. Also, in considering discrepancy in witness testimony, you should consider whether such discrepancy concerns an important fact or only a trivial detail. The testimony of one witness that you believe is sufficient to prove any fact. You should not decide any issue merely by counting the number of witnesses who have testified on the opposing sides. The final test in weighing conflicting testimony is the relative convincing force of the evidence, and not the relative number of witnesses who have testified on different sides of an issue. I have not intended by anything I have said or done to intimate or suggest what you should find to be the facts on any question submitted to you, or that I believe or disbelieve any witness, or believe the defendant to be guilty or not guilty. If anything I have done or said has seemed to so indicate, you will disregard it and form your own opinion. You must find the facts from the evidence. The evidence that you are to consider consists of testimony, witnesses, and exhibits. At times I've decided whether testimony, witnesses, and exhibits should be admitted. When an objection to a lawyer's question was sustained, you are to disregard the question. You are not to guess what the answer to the question might have been. When testimony was ordered stricken, you are not to consider that testimony as evidence. Do not concern yourselves with the reasons for these decisions. Admission of evidence in court is governed by the rules of law. Arguments and comments of counsel are intended to help you in understanding the evidence and applying the law. While arguments are not evidence, counsel may argue reasonable inferences from the evidence. If any comment of counsel has no basis in the evidence, you are to disregard that comment. In deciding whether the defendant is guilty or not guilty, do not consider the possible punishment. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. Your verdict must be unanimous. It is your duty as a juror to consult with one another, to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of your fellow jurors or for the mere purpose of returning a verdict. You are not partisans. You are judges of the facts. Your sole interest is to ascertain the truth of the evidence in the case. All six of you must agree upon a verdict. All six of you must agree whether the verdict is guilty or not guilty. When you go to the jury deliberation room, you will choose a presiding juror who will be in charge during your deliberations and who will sign any verdict. Also, you may proceed.
Good afternoon. First and foremost, let me say thank you. Thank you for your time, your attention. You've been with us for a long time, and we know that you have been diligent in your duties. It is only because of you, citizens like yourself who are willing to sit on juries, that our system works here in Arizona and throughout our country. This case started over a year and a half ago, March 21st, 2015. We started here in the courtroom over 6 weeks ago. And in the course of your deliberations and your thoughts, I'm asking you to go back 6 weeks and recall the testimony that you heard as the 8 boys in this case came forward and told you what they knew and told you what had happened. And I know it's been a while since you've heard their testimony, but I'm asking that you look to your notes. You have some exhibits that may help, but go back and reflect as to what their testimony was as this case began. Usually in a courtroom setting, we are formal, and I would be in the habit of calling people by their last name, Mr. Smith, Mrs. Smith, that type of setting. In this particular case, and I'm I guess apologizing up front, I'm going to be less formal than that because we have child victims in this case, and I don't want to use their last names. So I'm going to be referring to people by their first name, and again, because some of the adults in this case may tie to those children, I'll be using first names to the best of my ability throughout the case, throughout my argument, as to avoid that for the victims. I'm also asking, and you had a jury instruction that just was read to you, and it talks about the fact that arguments and statements of counsel are not evidence. And in the last weeks, you have heard lots of questions, lots of statements, lots of arguments from myself, from the defense, and even including at this moment, and nothing that we say is evidence in this case. If a question was asked, I ask you to look to the answer that came from the witness stand. When the witnesses are telling you the information, not the question that's asked, but the answer that's given, because that's where your evidence comes from. Exhibits that are put into the courtroom, evidence that is testified to by the witnesses, not my interpretation, not counsel's interpretation, not our statements. Going back to March 21st, into the morning hours of March 22nd of 2015. This was a day that should have been a day that Josh and his family would reflect back on, that 13th year, the celebration of his life, the bar mitzvah. Instead, by the morning of March 22nd, it became a night that 6 families will remember, that multiple boys will remember, not because of the celebration of Josh, but because of the behavior of the defendant. This case has never really been a whodunit, right? There really was no question in this case, as each of the witnesses testified. This was a known person. This was a person that they knew, they were familiar with. Even the defendant testified that she was in fact the person we were here about, that she's who we're talking about. It's never really even been a what happened, because the defendant's defense has been, as we heard as early as her original statement to Dana, my defense is, I don't remember. I was so drunk. So it's not even, did it happen, as the boys described that it did. It's not a matter of who was involved. Really, it comes down to whether or not the defendant is responsible for the behavior that occurred back on March 21st, 22nd of 2015. When you go back to deliberate, you're going to take with you 10 pieces of paper, 10 questions, if you will, that you're going to be asked to answer. Those are the 10 verdict forms that go to the 10 charges that you have been charged with deciding in this particular case. There are similarities in some of those charges, but they are all, as the judge has instructed you, distinct and separate. They all have their own individual facts, and each of them should be decided separate from one another. There is no need that any one or all of them be decided the same. It is up to you to look at each of those charges and decide whether or not the state has met its burden of proof. Now, I'm going to talk to you now, and the defense counsel is going to talk to you, and at the end of it, I'm going to talk to you one more time, and that's in the normal course of our criminal justice system. Because I do carry the burden of proof, I'll get the last word to speak to you at the end, and then it'll be up to you to make the decisions. We start with 2 counts of indecent exposure. Indecent exposure, as the judge described to you, comes down to a question of, did the defendant expose her areola or nipple of her breast with another person present, and was she reckless about whether or not that other person, as a reasonable person, would be offended or alarmed by that behavior? You're going to hear the word reasonable person throughout these instructions, and the reasonable person is up to you as a jury to decide, what does that reasonable person look like? And you may take I was indicating, a reasonable person is an objective standard. It's something that you will determine based on the objective standard of what is a reasonable person and how would they react to what is being done. Now, you may look to behaviors within the case of how the individuals who were present to give you some guidance as to what that looks like, but ultimately it will be your decision based on an objective reasonable person standard whether or not a reasonable person standing at that scene would be offended or alarmed by the defendant's behavior. That night, there are 2 counts, as I indicated. The first one starts off by the tables. You heard a lot in this case about the backyard and the layout of the backyard, and there were tables set up, and the purpose of which was for eating, for socializing, for the celebration that was at hand. You heard that there came a point in the evening where the defendant was at those tables, where she was socializing with others, according to her testimony, drinking with others, and the conversation became her breasts. Now, the people who were there with her told you this was her conversation. This was her subject, right? She wanted to show what had happened. Look, I've had augmentation done. Now, Heather made a comment about, yep, that's pretty obvious, right? I noticed, because remember the defendant said to her, hey, look what I had done, and she said, yeah, I noticed. But that was the conversation that the defendant was having that night. And it became, do you want to see them? Do you want to see them? And then it became showing them. And even the defendant acknowledges her shirt went up and her breasts were exposed. There really is no conflict there, no disagreement between the state's witnesses or the defense's witnesses that in fact the defendant at the table with others present lifted her shirt, exposed her breasts. The only question, and we'll talk about this, is whether or not her nipple or her areola was exposed. Now you heard from Jeff, who pretty much said to you, I had a front row seat, right? I was about 2 feet in front of her when the shirt went up, and I can tell you, I saw everything. It was all there. Now he went so far as to say, I'm familiar with, my wife wears, pasties. They weren't there. I could see it. I could see her. Nothing covering. The defendant had distinguished between only adults were present at that table, but the witnesses you heard, including the children who testified, said, no, I saw it too. Right? You remember that PJ talked about being out at the back fence. He was picking up a bag, and when he turned back around, there was the defendant. He saw it, and he described it. Right? He said, that's weird. He went on in. And Josh told you he saw it. And the parents who were present said, we physically grabbed the shirt to make sure it didn't keep going up and down because there were kids present. Right? Stop this. This is not appropriate. You heard from Jen where she said the defendant wanted to actually came forward and said, can I show them? Can I show them? Meaning the children. And Jen said, no. They're too young. You can't do this. But I guess I want to take a step back and say to you, would it even be okay if it was only adults present? This was a bar mitzvah party for a 13-year-old. There's no doubt there were kids at the party. Would it be appropriate from a reasonable person standard for the defendant to lift her shirt and expose her breasts, even if only to adults? In this case, it wasn't just adults. We know that. We know that from the testimony that we heard. And you look at that setting and you look at those facts to determine, did she expose? Were people present? And would a reasonable person be offended or alarmed by that behavior? Now, there was questions by me as we whirled through, and I asked each of the witnesses as they came to the stand, did you actually see the dark inner circle, the nipple on the breast? And the reason that I do that is not just to ask a question. It's because this is the time. This is the trial. This is the testimony that you have to have. Because one of the elements I have to prove is that, in fact, that portion of her breast was exposed. And the only way to prove that is to ask the witnesses. They have to give that testimony. So that's why, as they each came up, I said, did you? And they said, yes. Yes. And there was nothing covering them. So the behavior continues. And now, and again, we hear from the defendant that the next place it happens is at the pool. That's your next count. Where the defendant climbs up on the back of the slide, the rock slide on the back of the pool, jumps into the pool, and before she goes in, up goes that shirt again. And again, children were present. The defendant's own statements, and you have heard these statements, you've heard the recordings of these statements here in court, where the defendant said, in her original telephone call with Dana, I should really not be doing this right now, right in front of these kids. When asked, do you remember showing the boys after I walked away when you jumped into the pool and all the little boys at the party saw? And the defendant said, yes. I honestly thought back and I do remember that. I do remember that. She goes on in that statement. And she says, and I know I'm an adult, and I know that what I flashed the kids earlier, and I know that's what I did. I know that's what I did. I know my actions of lifting up my shirt, jumping into the pool. I know how wrong that is. And when asked again, why did you even start with taking up your top and showing the kids after we told you not to? And she said, I know. That was stupid. The conversation continued with the detectives later that day. When asked again, do you remember? And she said, I know for sure what I do remember. Is that I do remember, and this is embarrassing, lifting up my shirt to allow the adults at the party to see my boobs. And I remember after that I jumped into the pool and I did flash up my shirt. And apparently there were children present, boys around that saw that. And then finally, in detail, tell us what happened at the pool. And she said, I just remember. The only thing I remember is one of the boys asked me to go up and jump off the rock ledge into the pool. And Jen, she jumped into the pool as well with her son. And so I did go ahead and get up there and do it. And I do remember flashing, lifting my shirt as I was jumping in. I do remember that. That's your second count of indecent exposure. Were there people present when the defendant exposed her breasts? Would a reasonable person be offended or alarmed? Then the question became, as this case began, was she wearing pasties? Was there something covering her nipple? As you remember in her earlier statement to Dana when she said, my defense is I don't remember, I was really drunk. But now her defense is, I had on pasties. So I don't really show my breast, the inside of my breast. I did flash, I did lift my shirt, and those people were present, but didn't see my nipples. But I think we finally have some clarity on that. And we got that clarity when we heard from Dana. Because the defendant said, I got them from Dana, right? So Dana had to own something in order for the defendant to use them. And she came in and described to you the only thing she owned. The only thing she owned, right? Had them for years. Used them over and over again. A latex covering that slips inside of a garment. Has to be held in place somehow. Has to be secure because they won't stay. They're not adhesive. They're not sticky. Some clarity. What was even available to the defendant? So maybe it starts to make sense when Dana says in that first picture, oh, you know what, at the bar mitzvah, when she stands up and she reaches across, I see that outline of what would be that latex covering. Cold room, tight shirt. Maybe she got it to stay in place. Maybe she thought she should do that. But then defense counsel showed her defense 30, that picture of later in the evening, to show she still had that same shirt on, but something was different. And Dana said, yeah, they're not there anymore. I can now see your nipples. And the problem is, for the defendant, is they won't stay in place. They're not meant to just sit inside a shirt. They're meant to be held in place somehow. They're not adhesive. So by the time you get back to the house and you're moving around and you're talking and you're drinking and you're socializing with people, they're slipping around and they're not staying where you might want them to stay. But everybody got casual, right? We saw the picture. Dana came back, switched out of her formal clothes, switched into blue jeans. The defendant put on some blue jeans at some point. They got casual. Not there. Not there. And what do we know without a doubt? From what Dana described, the only thing she had available is that standing by that table, the first time that shirt goes up, even if she still had the coverings on at that point, which pictures would indicate she did not, but even if she did, that's what Dana testified to. By the time that shirt comes up, they're not staying in place, right? Well, nobody saw anything come flying off. They're not there. Shirt goes up, bare breasts exposed. And remember, Jeff, that front row seat. Certainly by the time the defendant walks to the pool and lifts that shirt up for the second time, going into the pool, there's no coverings in place. There's nothing. There's nothing. And the witnesses told you that they saw her bare breasts. Those are the first two charges that you'll be asked to consider. From that point, the defendant engages in a course of conduct throughout that evening that begins to lure in, entice, and encourage these teenage boys. We hear that from the pool, she went into the closet where she switched out to a sweatsuit. Not her t-shirt that she wore to the party, but a sweatsuit of Dana's with a zipper on the front. And when she came out of that closet, she unzipped that zipper and she flashed those boys again. Did they ask? I don't know. They might have. That's what she was looking for. That was the attention that she wanted. Following that flash in the closet, we hear that she continues out in the kitchen where her behavior for attention goes on, at some point throwing limes at Sammy. And no one else is throwing things. Folks, nobody else is taking their clothes off. Even other people who were drinking, who were socializing, who were having a good time that night, they weren't doing the things the defendant was doing. From the kitchen, hear from David and Joey and Austin as they're now engaging in conversation with her, right? She's got their attention. Not surprising. She has their attention, and they walk down that hallway into Sammy's room. And now we go to the next set of crimes, the next questions that you'll be asked to consider. There are 8 counts of public sexual indecency, which requires that the defendant intentionally or knowingly engage in an act of sexual contact with another person present and is again reckless as to such other person as a reasonable person being offended or alarmed. In this case, you have 8 kids who have testified that in the course of this evening, in 2 different bedrooms, the defendant engaged in sexual contact with each of them while other people were present. Every one of them testified, I was there when someone else was engaged with her. I saw other people touching and fondling and licking, engaged with the defendant in an act of sexual contact. They were present. Start with your first 3. David, Austin, and Joey. They walk into Sammy's room, and the defendant is standing up, upright, having a conversation. And you heard David talk about, will you show us again? What do they feel like? And the defendant unzips her jacket and says, you can feel them. And she steps closer. And as those 3 young men stand side by side and reach out and touch the defendant's breasts, with each of their friends present, you have to then decide, as each of them witnessed this happening, would a reasonable person in their place be offended or alarmed by what is going on? His room, you hear again from David that contact and conversation happens, and the defendant again unzips her jacket and invites that contact. You can feel them. It's okay. For Austin, one of those 3, it goes on. Austin tells you that in the course of the evening, he is present in a room when the defendant is engaged in oral sex with David.
Objection relevant?
That he, in fact, sees sexual contact not just with the defendant's breast, but with David's penis. And he tells you...
Objection, may we approach?
Sure.
as I was saying, when Austin is present, he's seeing even more. He's seeing the actual contact, as David described, where she touches his penis and ultimately puts it in her mouth. The question becomes, in that moment, is someone else present? And the answer is yes. Austin is present. As a reasonable person, would a reasonable person be offended or alarmed at what is being observed in that room? Each of them describe others being present, others being in the room and observing as their 13, 14, 15-year-old friends are invited, persuaded, and ultimately caused to touch the defendant. We move on then in Josh's room as 5 other boys testify that they're also in that room that night, and each one of them describes the interaction they have with the defendant, the conversations that are ongoing, and the contact, the sexual contact that continues in that room in their presence. We heard from Brady, who indicates that it was an alarming event, that in fact he's there when he hears the defendant invite Josh, saying something to the effect of, "It's your bar mitzvah gift. Come on in. Do this. You can do this." He indicates...
Understood,
counsel, the argument that the jurors will have to rely on their notes regarding the testimony.
Thank you, Your Honor.
Thank you, sir.
He indicates that he is ultimately present when, in fact, Josh does touch. He indicates that himself, as he's there, he's asked by the defendant, "Go ahead, you can touch," and he declined. No. And the defendant, according to Brady, literally takes his hand and moves it in the direction of her breasts. She releases, and he touches, and others are present when that is going on. Would a reasonable person find that to be offensive or alarming? As 13-year-old Brady is encouraged and literally physically moved towards the defendant's bare breasts. We heard from Eric, who says he saw it outside, he saw the flash in the closet, and the defendant was talking to him, saying to him, "It's okay. You can touch." Again, Eric said to us in testimony, it was weird. It's his reaction to this is weird. PJ, 13, says that when he is there in Josh's room, the defendant specifically speaks to him. Who are you? Who is this? He says, "PJ." She says, "Oh, okay. Come on in." And he says, "Josh is right beside me while this is happening." Josh, 13, says, like Brady, the defendant spoke directly to me. Did he call him by name, or did she just refer to the bar mitzvah? He was the only one there having a bar mitzvah. But again, that encouragement. Come on. And Josh said, no. Until encouraged along by the defendant. Come on. It's okay. You can do this. And others were there when he did. And then you heard from Sammy, the 11-year-old, who said, "I was in and out of that room that night, and I saw multiple people engaged with the defendant." And the defendant, he could hear her saying, "It feels like a massage." She's talking and laughing at that. Would a reasonable person be offended or alarmed at the behavior that night as the defendant engaged in sexual contact, and the judge read to you the definition, and it talks about directly or indirectly touching, fondling, or manipulating any part of the genitals, anus or female breast, by any part of the body or any object, or causing another person to do so. And you have a definition for cause. Something or someone that produces an effect or condition. Something or someone that makes something happen or exist. That is exactly what the defendant did that night. She caused all of this to happen. She caused this outcome when she made a choice to turn a 13-year-old's party into her personal stage of attention. Look at me. Look what I have. The question before you, as you go back to deliberate, is not, did the boys touch voluntarily? There came a point when they probably did. That encouragement, that luring in, and the teenagers thought, okay, right? Probably even heard a few of them say, yeah. That doesn't forgive the defendant's behavior. That does not make it okay that the boys in this case ultimately went along. It's the causation of all of this that falls to the defendant. Did the defendant engage in or cause to occur this conduct? But for the defendant's behavior that night, we're not here. We're not here talking today. But for the defendant's behavior that night. So the questions that you have to ask yourself is, did this happen? Did the contact happen? Were there other people present as each of these events are taking place? And was the defendant reckless to disregard the risk involved with that other person as a reasonable person being offended or alarmed? And again, I ask you to look to the evidence from the witnesses who testified and use your common sense as to the causation of what happened. Dana said to you during her testimony, she seduced these boys all night long. Starts at the tables, moves through the house, into the bedrooms. Could they have said no? They could have. But they're children. And they didn't. And the defendant was the grown-up in the room. Have you ever watched one of those specials where they gather parents together with children and they ask them, have you taught your kids about gun safety? They go, oh yeah, my kids would never touch a gun, ever. They would find an adult, they would tell us what happened. They put those kids in a room with a gun, and within minutes, right, the kids are not only playing with it, they're pointing it at each other. The parents are thinking, oh my gosh, I never would have thought my kids would do something like that. You tell the parents, you need to put your guns away, right? You don't lay them out on the table and hope that the kids remember the lesson. Put the guns away. Defendant was looking for attention that night. From the moment she arrives and she starts this conversation, do you want to touch them? Did you see I got new ones? They feel kind of funny. Do yours feel like this? Do you want to see them? Do you want to touch them? Does anybody want to look at them? Somebody should. Starts in the yard, heads to the pool, ends up in a closet. Jeff tells you about his encounter with the defendant at the front door. Now she said that didn't happen. Not she wasn't there, because she was, right? Vividly remembers being there at the front door when Dana and Gina disagree, get into it. She was there, just not that thing with Jeff. That didn't happen. I didn't throw myself at him. Sammy's room. Don't remember any of that. Don't remember that happening. How about Alan in David's room? Looking for David, looking for attention? How about throwing limes at the guest, at the child? Or throwing cake at the host? Those screams for attention throughout that. Look at me. Look at me. And then ultimately Josh's room that night. You know, sometimes we talk about, even bad attention is better than no attention. Well, that night the defendant got lots of attention. To talk for a second about Alan and talk about what happened in David's room. And it's not so much what happened with Alan, not a charge that's looking at you or that you have to make a decision on, but I think it tells you volumes about the defendant and her credibility in this case. And you are the judges of credibility. And you have to look at the testimony and say, do I find this to be credible? So think back. How many different versions of that event you heard from the defendant? It started off with, I remember going into that room and kissing him. And then Craig came in and I walked into that side bathroom. And one of the boys asked me to go in that room, and Alan was in there, and so I went in there and I kissed him, and Craig walked in. And then Alan asked me to go in the room, and I did, and kissed me. He kissed me. And then you heard from the witness stand, Alan literally dragged her into that room, forced her in there. She had no idea what was about to happen. Slammed that door and kissed her, because Alan's big. He's a big guy. Casting shadows. I think that's what you heard it called. Casting shadows on other people to take them off of yourself. Right? But what does the event with Alan really tell you about the evening? Does it matter so much, how they ended up in there together? As the defendant said numerous times in her early statements, he's 18. So, it may not be good, but it wasn't bad. What does it really tell you, though? It tells you that she was exactly where the boys said she was. Because Sammy's room is right across the hall from David's room. And the three that were in Sammy's room said, Alan was across the hall in my room, and that's where she went. Did she go there because they said, hey, go over there, or because Alan said, come on over, or she just walked in by herself? I don't know. But she was exactly where they said she was. And she remembers it. Because remember, her defense is, I don't remember. But she does. She remembers Alan's room, or David's room. She remembers being in there with Alan. She has lots of versions of how it happened, but she remembers it. And it's right across from when David and Joey and Austin said, that's the first time she let us touch her. She was exactly where they said she was. And she remembers it. There are no drugs in this case. You have no evidence of any drugs. There is alcohol. There may be a lot of alcohol. I went through with the defendant kind of the evening. Again, not so much for, did she really drink that much? I don't know. I'm not sure anybody really knows. She said she did. She said over the course of, from the hors d'oeuvres till 1:30 in the morning, she was drinking. I don't really know how much she drank. But what I do know from the evidence there is that all of that, whatever of it she consumed voluntarily. She chose to drink. She chose to drink. And she drank. And the law says, and it's in your instructions, that voluntary intoxication is not a defense to criminal behavior. Not a defense. It doesn't negate the mental state. Because you don't recognize the risk that you are putting other people in because you're drunk, doesn't work. The law says you are responsible when you choose to drink. Makes sense if you think about how easy that would be. Yes, I robbed the bank, but I was really, really drunk. Law doesn't care. Law does not allow for this defense. I was drinking. The interesting thing about this, and part of the reason that I laid it out, was really not for how many drinks were consumed, but that she consumed them and that she remembers consuming them. And we filled in the blanks. And the only thing missing from her memory that night is the voice. The trip to the closet, the trip to Sammy's room, the trip to Josh's room. Everything else, crystal clear. I have a full memory. She drank voluntarily. She had conversations ongoing throughout the evening, and you heard people talk about it. She was actually the catalyst in the drinking category, right? You heard from Heather. She was saying, come on, drink with me. Drink with me. It's all right. Stay the night. Just drink. I said, no thanks. I'm going to drive home tonight. And Dana, drink with me. Come on, have a shot. I'll have a shot, but you have to go teach tomorrow. Okay. I'm okay with that. And at the end of that evening, 1:30 in the morning, she remembered the conversation with Dana. She remembered she had to go to work. She set an alarm. She got up to the alarm. She got ready and she went and taught hot yoga. No problem. Didn't get sick. Didn't complain about not being able to do that. So I don't know how drunk she was. I don't know what her capacity is for alcohol. All I know for sure is that whatever she drank voluntarily. It's not a defense to what she did. And she remembers everything except the voice. There are no drugs. Say it again. There are no drugs in this case. You have absolutely no evidence that there was anything in the defendant's system except what she put there. No evidence. Their own expert, the guy they went to for tests.
Good. Not our expert.
Probably does if this in the testimony page.
The guy they hired to do the tests. The tests the defendant quoted when she thought they said GHB. We found out from the doctor that's not what that says. Nobody gave you any drugs. No drugs in your system. Now, we don't even believe those tests. We don't even think they're valid anymore. Okay, take them out. You have no evidence of anything except that. She drank. She said, my defense is, I was really drunk, and I just don't remember. The officers asked her, I apologize. She said, I don't remember anything, right? From the earliest conversation with Dana, all the way through, I don't remember. Just don't remember. Now, we've spent a lot of time in the last 6 weeks hearing about bad people, right? Bad parents, bad kids, other behaviors. When you go back to deliberate, I want you to ask yourself, what does any of that have to do with the 10 questions you have to answer? There are 10 questions you have to answer. Did the defendant expose her breasts? Was someone else present? Would a reasonable person be offended by that? Did she engage in sexual contact or cause others to with anyone present? And would a reasonable person be offended or alarmed by that behavior? Early on, she told the detectives, I'm not saying it didn't happen. I'm just saying I don't remember. Her memory is very convenient when you look at that night When you look at all that she does remember. Alan, not good, but he's 18. Right? We heard that excuse. He's 18. Only thing missing is the boys. Did the defendant engage in the conduct that the state has alleged? That is the question you're being asked to answer. That's the verdicts that you're asked to give. The answer in 10 cases is yes.
And then we'll need a break. So now we'll break.
You want to break now, or you want to break later?
Let's break it through.
It's not. Make it possible. If they want to. Want to go soon up?
Yes.
Sorry.
Thank you. I want to go now and break it.
That's what I thought.
Thank you, Judge.